felt this morning. Right? So thank you for being here. Thank you for the our hosts. Thanks to the speakers, and I think it has been so far a very productive day. So I'm very happy to be with you now. Just to give some basic information to the speakers and to all of you. So we will have like 20-25 minutes of panel discussion and then some extra Q&A, if any, from the audience. And then I would like just to spend a couple of minutes to introduce you to the EU-Japan Technology Transfer Helpdesk and show you the website that we are operating and how it works. And then we will all be ready for the well-deserved reception. So stay with us. So I would like to follow in order that I had today with the presentations and with the speakers. I would like to start with Dr. Oldekop and about the presentation on the possibility of the right of inspection. And I would like to know you talk about Germany and France and the different procedures. So are there any other countries in Europe that might be worth mentioning because there are some similar procedures, especially for those that maybe might have branches from other countries in Europe?
Yes, there are, certainly. This is first of all because, as I mentioned, this inspection regime comes down from another directive, the Enforcement Directive, which is, of course, transposed in all the other member states of the European Union. In some countries with a bit of delay, but at the end of the day you find similar proceedings in all member states. I want to emphasize that in Belgium, for example, the saisie contrefaçon is also known for a long time, and in the UK you have also before the Enforcement Directive has been adopted, the so-called Anton Pillar doctrine, an order which also allows for inspection, which very effective measures actually, and basically all those proceedings work the same way as was what I presented before in Germany and France. Of course, there are some specifications in some of the countries, but basically the answer is yes. You have those kinds of proceedings in Europe all over the place.
Do you see any potential interference between these procedures, I mean specifically that you mentioned, you explained these others, and the implementation of the directive, the Trade Secrets Directive?
Well, what is true is that in many occasions, almost all cases, trade secrets of the defendant are touched, and as we heard, those trade secrets shall be protected in general. But in the specific situation of an inspection, when at the end of the day the court decides that the report containing the trade secret is given to the plaintiff, this is acknowledged by the court, so it's legitimate, and so this won't be any unlawful acquisition or use from the plaintiff's side. This is one thing, and the other thing is that just simply by giving this trade secret to the plaintiff, it does not become generally known, so it's still protected. And thirdly, the fact that the plaintiff receives this trade secret information for using it as a piece of evidence, this does not mean that he's allowed to use it beyond this reason. So he can use it to prove his case, the court might, on the application of the defendant, also order that the trade secret shall stay within the court proceedings and not go outside, and then it remains protected and is used as an evidence. So my answer to your question in short is no.
Okay, thank you. Moving to the other table, Matsunaga-san, thank you for the presentation. Unfortunately, my Japanese is not that good, actually. It's very awful, and you were super fast. So anyway, I couldn't follow you.
Sorry.
I was very interested, especially in the last part of the presentation, and also this is another question for the Trade Secrets Directive. How, especially now with the market is becoming, as you said, more fluid, so with employees that are moving from one company to another, how do you see this kind of identification of trade secrets once someone is being hired, and then during the relationship with the company, and then when he's leaving? So you talk about the potential effects for the new employer that should be aware of what happened before and the trade secret. So how this will work in practice? So the person will leave the company, will have a kind of a binder with all the things that should be considered trade secrets. They cannot be used, they cannot be disclosed. How will it work?
Yes, practically speaking, there should be a limit that the extent you may know what's the ground, or what's the specific trade secret this employee have touched or working for in the previous employer, of course, because this is trade secret that this employee has to is committed not to disclose to the candidate of new employer. So when we advise to our client who's willing to have this interview to the new candidate who they wish to hire, is to try as much as possible to see what kind of research he or she was committed, engaged, and so from the overall information, because they are basically competitors, or at least the company who's producing similar products in the similar industry, so they can make some assumptions. So from the facts they learn from individual interviews, they have to make some list, and afterwards, in the group of, for example, the R&D team, they will discuss, okay, so what kind of technology this company has already developed may conflict with the company which this former employee has been working for. This kind of conflict could be discussed and predicted, and then finally the HR has to make the final decision if he is okay to be hired, or he is okay to work for this specific division, because there should be the possibility, even if they has a certain mind that or information or decision that so this person cannot be work in this specific R&D team, yet they do have, if they do have this different team, which the main focus is different from this business secrecy of the former company, then it should be all right. So they may decide to hire this person in a different R&D team. And then even if they happen to get this warning letter from his former employer that they can respond to it. Yeah, we have hired this person for this research, this kind of research, which we believe is different from your main focus or the division he used to work for. So I wanted to emphasize in the last part of my presentation was to make somehow try to figure out the clear this definition of, even if to some extent, as much as possible, and so that they could avoid the risk of contamination, or to well prepare for counter argument in the future. Am I clear to your question?
You're very clear. This is the side of the future. What what about the past? I think from the translation I realized that you were talking also about maybe a meeting at the end of the relationship between the employee with the former employer. So this is something that happens, or it will happen increasingly with the more fluid market. So there will be a final conversation between the HR department, the legal department, and the person that is leaving, warning this person, look, these things are really, really important. You cannot disclose it, especially if there are people that are not. Maybe in 30 years in a country, they move to different departments, so they learn different things.
Yes, and if I can add more one other point of view, maybe if you are willing to hire this person to have him engage in a certain research work, then they can explain the area of such research, and then ask him that with some listing, do you have ever worked in this area in your former company? And if his answer is yes, you can elaborate on some more information about the specific research group in which he is going to be hired. Then you could just make this listing to which he will answer yes and no. And then you could just furnish this evidence for future counter argument. And that may work to prove the no intent of this company to infringe or make the violation of business secrecy of his former company. So these kind of attempts are being done by the Japanese or even the multinational company who has R&D center in Japanese cities.
So,
Want to jump in? Yes, please.
I may add that, of course, this situation of the change of an employee is always a big problem for the company. I mean, the company has to believe if the new guy in the company says, well, all information I bring with you, I do bring it lawfully and legitimately obtained it, and I did not make any copy or whatever. You have to believe it. And now seeing that with the directive in Europe, there will be a liability without fault for acquisition or use of a trade secret. This of course leads to liability for injunctive relief, for example. And this is going to be a problem for companies. So they have to be very, very careful, but at the end of the day, there will be no 100% protection. And no, I think there will be no absolute. They cannot be absolutely sure.
Yeah, this is true, as is the case in Japanese situation, because this evidence that I advise to furnish is to avoid claim for damages. That is only possible in case you are has an intent or a gloss or normal negligence. However, when it comes to the injunctive relief, it's unavoidable.
Yeah, same is true here.
Thank you. I will switch to my neighbor here, Dr. Pao. Thank you for the very, very clear presentation. I don't have any questions beyond the one that I asked you before as to the ceiling about the unitary patent. But I do have some questions for the part on the employees invention. So we will talk about universities and the reason why these are so important, especially for the Helpdesk. So I'm very interested. You mentioned the statutory provisions for inventors in that world. Do you have some examples that you can share of inventions that came from university academia, especially in Germany, but in general in Europe, that have been a success or are being a success?
Thinking about that, there is, of course, always research at the universities. I have the impression that the whole patent business, of course, is not that big in universities. Research is done. Also, patenting is done, but in a special way, because the universities, at least what I know from German universities, I guess it's more or less the same with universities in other European countries, they do not have the personnel and the manpower to apply for patent protection on their own. So what they do is they organize themselves by establishing so-called innovation agencies or innovation management agencies that are basically private companies that cooperate with the universities and handling all the patent prosecution for the universities. If a patent is then granted and if the university receives money for such a patent, for example, by licensing it out, then, as we saw already, the inventor will receive a remuneration of 30%, and those agencies will also receive, as their kind of salary, also receive a share of the remuneration, which is around, I would say, 5 to 15%. So that said, when I think of what would be in inventions that were a success on the market, one thing comes to my mind, which is the development of the data type of MP3 in the, I guess, 1980s or early 1990s, which was co-invented in the University of Nuremberg, and they are very proud about that, of course. And nowadays, I have the impression, because I don't know about any blockbuster invention, but I have the impression that much is done in the field of life science, such as antigens, for example, or animal models, things like that. There is also, because many universities have electronic engineering, so there is inventions on that field, but not that I knew that there is one specific invention that is the big invention.
So always to you. In this specific regard, do you think that there are, like in the US, sometimes, the proceeds, we know that in universities are much higher. Then maybe I will give you some statistics to tell you how much higher compared to Europe or Japan. Do you think that it's kind of common for the professor then maybe to share or give back part of the potential revenues, or would be in the future maybe an idea for the inventor to share part of the revenues and give them back to the university they belong to? Because this is something that in the US happens, not most of the times, but sometimes.
Good question, and actually a tough question. So this let's say system of invention management at the universities started not too long ago, beginning of 2000s, like 2002. There was this like change in the law in Germany with regard to how to treat invention in universities. I have the feeling that due to the fact that the universities cooperate, as already mentioned, with these IP realization agencies, or how you may call them, that the professors have the feeling that they earned this amount of money that they receive as a remuneration, and may probably use it to refinance their own development internally, but I don't have the impression that they simply give back the money to the university for their free discretion.
Thank you. Jumping, but always talking about universities, and you mentioned in your presentations very nice schematics about how to develop pharmaceutical products. So I was wondering, in your experience, especially since you have been an in-house counsel for decades, how, but you also know I'm sure the world of academia, how is different in terms of remuneration, the treatment between inventors in academia versus the corporate world? If it is different, of course.
May I speak in Japanese?
Yes. Give me 1 second.
私自身、企業の経験しかございませんので、なかなかこう大学の実態っていうのをこう素直に話せるっていうのは、なかなか少ないトピックかと思います。で、今日は会場に大学の関係者の方も多分来てらっしゃるのではないかと思いまして、そちらの方に聞いてもらった方がダイレクトじゃないのかなという気もしております。ただ職務集めに関しましては、まあ、法律があって、それに沿った形で企業もそうですし、大学もそれに沿った形で、各々の大学での職務集め規定を作っているというふうな状況だろうと思います。で、何らかの形で出願時保証であるとか、登録時保証であるとか、実績保証に近いようなものを支払っているのだろうと思います。で、実績保証に関しましては、企業と違うところはやっぱり企業が自分のところでこう製品自体を売ったりしますので、まあ、その売上等が容易に分かるわけでございますけれども、まあ、大学においてはなかなか自分で実施するっていう機会は少ないでしょうから、まあ、企業から得られるライセンス収入あたりで計算することが多いんだろうと思います。で、一点そういう意味では、先ほどの説明の中でちょっと抜けてたかもしれないんですけども、まあ、ライセンス収入という意味では、まあ、企業に比べたら、やっぱり若干、大学の始め者っていう方がまあ報酬という意味では少なくなってしまうのかなというふうに思います。ただ今回の改正で、先ほど相当の対価から相当の利益にまあ、言葉としては変わりましたというところがございました。ただ留意すべきところはですね、まあ、基本的にガイドラインの方でも言われておるんですけども、原資は変えないというところがございますので、まあ、今まで、対価から利益になったのでまあ、少なくしてもいいんですよというふうに勝手に、やっちゃうと、やっぱり将来のリスクが問われますので、まあ、私も退社するときまでには社内の職務集め規定を変えて退社いたしましたけれども、まあ、そこの原資のところは、まあ、今まで支払ってたのと同じレベルである時期において支払うような形のシステムに変えて、出てまいりました。
Thank you for answering the question. I have also for your experience in the corporate world, I'm wondering whether you had in your experience had the chance to scout for technologies outside of the company, so looking for technology in universities, and if you did, do you think there is any difference between technologies that are being developed here in Japan or that are developed outside of Japan? So if you were in the position right now to scout for technologies outside for a company, where would you go? Would you have any preference?
具体的に挙げると、ちょっと多少影響があるところもあるかもしれないので、一般的にぼやかした形で答えたいと思いますけれども、まあ一般的に言われているところはアメリカの大学との連携が多かったように思います。カリフォルニアであるとか、まあ、ボストンであるとか、結構いろんな研究機関があったと思います。まあ、国内におきましたら、やっぱり、私どもの分野では再生医療を中心としてですね、京大の山中先生のところとの共同研究っていうのは、やっぱり皆さん、各社さんやられてたような気がします。で、そういった意味で、やっぱり最近はオープンイノベーションというか、自社の中で技術をすべて、獲得するということがもうほとんど難しくなってきておりますので、やはり専門のですね、大学あるいは研究機関と組んだ上で、やっぱり基礎研究を進めていくと
いうあたりが一般的にやられておりますか。
Thank you. Definitely answer my question, especially with the keyword open innovation that, as you said, are really hot right now. So, thank you. I would like to close this round with the last question for Dr. Oldekop, always about trade secrets. I'm very interested because I'm working a lot with SMEs and startups. So, in view of the future implementation, what are the practical insights that you would give to a company, especially to a startup with SME that, as you probably know, will probably not have the help of an in-house counsel because they cannot afford one. But if they will have the chance to talk to one like yourself, what will probably be the basic pillars that you will give in terms of identification of potential trade secrets inside the company and how to mark them, how to store them, etc. And this is then maybe a question that I would like also one of the Japanese speakers to answer with the Japanese view, of course. Thank you.
Okay, thank you. I have to admit that since the law with regard to the measures for keeping information secret will change in Europe in the next years, we do not have that much experience on the specific measures yet. I'm pretty sure that Shogo can give a lot of more details since in Japan you are far ahead with regard to those measurements. However, of course, I mean, generally speaking, what you need to do, and as I mentioned in my presentation at the end, that you definitely have to do is first to identify your know-how, and also a kind of establish a kind of information management in terms to distinguish who has to know what, and maybe distribute your information, the relevant information among various persons. And besides that, of course, there are a lot of different physical and electronic measures how you can actually protect. And well, I can't and I do not want to go into detail on those kind of restriction measures or control measures. But what I can say is, from a legal perspective, that there are, of course, some contractual measures which you can enter in, like non-disclosure agreements with other companies or with your research colleagues, and contractual limitations as to the use of information disclosed to somebody else. For example, what is admissible is that if you work together with somebody else, that you restrict the use in terms of that you do not allow reverse engineering, which, as we heard, would be a lawful way to acquire information. But you can limit that down by way of a contract or an agreement. You can enter into non-compete agreements with your employees. In case they leave the company, that they are not allowed, at least for a limited period of time, to compete in the same technical fields. But as I said, if it comes to detailed measures, maybe Shogo can say something, can add something.
So your question is about detailed measurement. Is it related to the definition of trade secrecy, or?
Well, no, in the opportunities for a company, especially a small one, to identify, I mean, very kind of practical insight or recommendation on how to identify and store. Now we're talking about a lot of data that is digital. So even in fields that are not strictly related to ICT, maybe it can be genomics, genetics, still, because digital data can travel as fast as light. So.
It's same as in the situation in European country. There are a lot of the criteria or standard you could discuss on, to make this trade secrecy with a clear definition even before court. Well, it's a long discussion, and well, as I previously discussed, that the predictability was always the issue, because in the past time, in around from until mid of 2000, well, because of the strict definition set up by court or maybe MIT, well, people almost give it up in the middle of establishing this kind of regulation, internal regulations of each company, especially for a smaller entity. Well, they cannot allow the time or investment on creating such regulations where they are not clearly understand if this regulation is okay to be regarded as the trade secrecy by under the law. So, however, because of the recent development of the court proceedings, and also which is duly supported by the guideline by MIT, it is more of easy standard. Generally speaking, I advise to at least make this storage of hardware or cloud, whatever. Restrict the people who may access to a certain grade of the people. For example, in our R&D team, maybe manager class can be only accessible, for example, with some password which is supposed to be changed periodically, and you should have this regulation that how you deal with this kind of information. If you print this out, you have to make clear indication on the file or the each document which clearly describes this is the company's business secrets and so on. And education and this kind of physical remedy should be considered. But to this extent, we can in my opinion, I can assert this is protected by company secret as a company secrecy, business secrecy. So sorry, I cannot just give you the clear, practice. It depends on the size of the company, the nature of the business secrecy you may have. So it depends. But however, this might be the minimum standard.
Thank you, and please go ahead. I can see you're ready.
I may add one thing. The European directive was somewhat inspired by the US Trade Secret Act, and what I learned now is that people in Europe, just making up their minds about the question you had, they look into the US case law to establish what are the precedents there, and what you can just very basically say is that there has to be a proportionality in terms of how important is a trade secret, and as you said, how big is the company, what budget do they have, compared to the specific measure to take. I mean, for a big high-tech company, you can expect more and higher sophisticated measure as for example. But one thing is very important, and this becomes clear if you look at the US presidents. The first thing you have to do is let your employees know that this information is a secret, like stamping it with a confidential stamp.
Thank you very much, and this, I think, closes basically our short panel. Unfortunately, time is what it is. Time flies. So, thank you very much. I would like to thank once again the speakers for being with us, and you, of course, the audience, for being here. I would just like to take 5 minutes of your time to introduce you to the services of the Helpdesk and show you how it works, because actually it's a website with ancillary services, and then I'm sure we'll be ready to go. Well, thank you once again for being with us.
Thank you.
And you can stay here if you want.